Greetings aspirants. Hope you all are doing well. Recently, there has been an issue in the news. A married woman who is 26 weeks pregnant has approached the Supreme Court seeking to terminate her pregnancy, citing inability to take care of the child due to postpartum depression and other health issues. She has two other children too. So the Supreme Court on October 9th agreed to her plea, but 2 days later, a two-judge bench delivered a split verdict when the government brandished a report from the All India Institute of Medical Sciences. This report said that the fetus was viable and had a heartbeat. So, aborting it at this stage would mean either putting a stop to the heartbeat or delivering the baby prematurely, which might lead to severe complications, both mental and physical, for the child. This case was then referred to a larger bench headed by the Chief Justice of India, which has observed that the highest court of the land cannot overlook the rights of an unborn child, thus igniting a pro-life versus pro-choice debate. So, in this context, we'll talk about the Medical Termination of Pregnancy Amendment Act 2021, its salient features, changes from the earlier act, and then we'll try to look at the issues with the act. Now, what is this act about? See, the Medical Termination of Pregnancy Amendment Act 2021 is for expanding access of women to safe and legal abortion services on therapeutic, eugenic, humanitarian or social grounds. These amendments include substitution of certain subsections, insertion of certain new clauses under some sections in the existing Medical Termination of Pregnancy Act 1971, with a view to increase the upper gestation limit for termination of pregnancy under certain conditions and to strengthen the access to comprehensive abortion care under strict conditions without compromising service and quality of safe abortion. Hence, it is a step towards safety and well-being of the woman, and many women will be benefited by this. Recently, several petitions were received by the courts seeking permission for aborting pregnancies at a gestational age beyond the present permissible limit on the grounds of fetal abnormalities or pregnancies due to sexual violence faced by the woman. So, these amendments will increase the ambit and access of women to safe abortion services and will ensure dignity, autonomy, confidentiality, and justice for women who need to terminate pregnancy. So, if we look at the salient features of the amendments, firstly, the amendment enhances the upper gestation limit from 20 weeks to 24 weeks for special categories of women, which will be defined in the amendments to the Medical Termination of Pregnancy rules and would include survivors of rape, victims of incest, and other vulnerable women like differently abled women, minors, etc. Secondly, opinion of only one provider will be required up to 20 weeks of gestation and of two providers for termination of pregnancy of 20 to 24 weeks of gestation. Thirdly, the upper gestation limit will not apply to the cases of substantial fetal abnormalities diagnosed by the medical board. The composition, functions, and other details of the medical board will be prescribed subsequently in the rules under the Act. Then, the name and particulars of a woman whose pregnancy has been terminated shall not be revealed except to a person authorized in any law for the time being in force. Lastly, the ground of failure of contraceptive has been extended to woman and her partner. Also, this has been extended to unmarried women. So, on a whole, it is going to benefit a lot of women. But there are few issues associated with it too. What are the issues? See, firstly, there are differing opinions with regard to allowing abortions. One opinion is that terminating a pregnancy is the choice of the pregnant woman and a part of her reproductive rights. The other opinion is that the state has an obligation to protect life and hence should provide for the protection of the fetus. Across the world, countries set varying conditions and time limits for allowing abortions based on fetal health and risk to the pregnant woman. Secondly, several writ petitions have been filed by women seeking permission to abort pregnancies beyond 20 weeks due to fetal abnormalities or rape. The bill allows abortion after 24 weeks only in cases where a medical board diagnoses substantial fetal abnormalities. This implies that for a case requiring abortion due to rape that exceeds 24 weeks, the only recourse remains through a writ petition. Also, the bill does not provide a time frame within which the board must make its decision. Termination of pregnancies is a time-sensitive matter, and delays in the decision making by the medical board may result in further complications for the pregnant woman. Then, the Act does not specify categories of women who may terminate pregnancies between 20 to 24 weeks and leaves it to be prescribed through rules. It may be argued that such matters should be specified by Parliament and not delegated to the government. Next, the Act requires abortion to be performed only by doctors with specialization in gynecology or obstetrics. As there is a 75% shortage of such doctors in the community health centers in rural areas, pregnant women may continue to find it difficult to access facilities for safe abortions. Lastly, the Act allows pregnant women to terminate pregnancies under certain conditions. Note that the Transgender Persons Protections and Rights Act of 2019 recognizes transgender as an additional gender in India. Some medical studies have shown that there may be cases where persons who identify themselves as transgender and not women can become pregnant even after receiving hormone therapy to transition from female to male and may require termination services. Since the Act and the bill only provide for termination of pregnancies in case of the woman, it is unclear if the transgender persons will be covered under the Act. In conclusion, in the light of these issues, it is essential for the policymakers to carefully consider the implications of the proposed amendments. Addressing these concerns is crucial to ensure that women have access to safe and timely abortions, respecting their reproductive rights, while also safeguarding the interests of the unborn fetus as per the legal and ethical framework in place. The Act should further be reviewed and potentially refined to strike a balance between women's reproductive rights and the state's interest in protecting life. So, we have discussed all we need to know about the Act. We'll be back again with another topic.